All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in our case number CV23 0195, High Desert versus CEC. Counsel, we're recording and live streaming the argument, so please identify yourselves and your clients at the beginning of your argument. Each of you will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, if you'll watch the clock and reserve as much time as you'd like for rebuttal. Also, we've read the briefs, studied the record, and have discussed the case in conference. So, counsel for appellant, you may proceed.
Good morning, Your Honors. My name is David Abney. I'm representing the appellant. This may be the first time in a decade or two that I've not filed as many pages as the other side. My opening brief was 20 pages. The reply brief was 13. I came up with 33. And the answer brief was 75 pages. I wondered when I read it if I'd missed something, but I don't think so. It seems to be a fairly straightforward case. High Desert received a written request for an assignment and decided that it did not want to approve that. The contract, which is a very fine print thing, in fact, I got my magnifying glass. I may have to use it several times, but it's very detailed, very pro-lessor, and it gives the lessee the right to say, I don't want to approve your assignment if you're in default in any way. And a default is a failure to comply with any provision or part of the lease, which happened when the written request for an assignment did not come together with the $500 fee that's mandatory. The trial court seemed to regard this as all commercially a very unfair sort of thing, but just before the signature block, you've got the one part of the contract you can actually read without a magnifying glass in big, bold print, comparatively speaking. And it says, the lessor, quote, carefully read and reviewed the lease, and the terms of the lease are, quote, commercially reasonable, end quote, and they effectuate the intent and purpose of the lessor and the lessee. So you've got an admission right at the end of this lease that it's okay what's in the lease. It's commercially reasonable, and they're stuck by it. When I was reading the lease and going over the case, I had flashbacks to Contracts 1, my very first class actually in law school. I remember a Rappaport was the teacher, an adjunct professor, and he said, if it's in the contract, unless you get some sort of constitutional argument, it's an adhesion contract, and you're some sort of poor person, and you don't know how to read, and they put all these things in it, you're stuck with a contract. And here, these are sophisticated entities. Their managers signed off on the contract. It's got that clause right at the end warning them, and where they agree that it's commercially reasonable. And so when the request for an assignment came in without the $500 fee, at that point, there was an absolute right to reject the attempted assignment.
Counsel, I have a question. Where did you raise your attempted an assignment argument below?
I don't think they raised it very effectively. I think it's implicitly raised, but I don't think they specifically did it, quite frankly. I have to say that. I think the trial court accepted the fact that it was an attempted an assignment and it wasn't successful. But the only point I need to win on is this $500 fee came in together with. And my colleague across the aisle finds these dictionaries on the internet, which I never trust, by the way. Mine are in paper. But together with, it just means, common English, I'm going to give you a contract together with the $500. It's at the same time. It's not later. It's a simultaneous sort of thing. So I don't think you can cobble together an argument that together with some sort of ethereal meaning that's beyond common sense. I mean, the role of the courts is to interpret the contracts according to their plain meaning. And not only the plain meaning, the Supreme Court has, in the last couple of years, been very emphatic that there is indeed a freedom of contract, and it's a freedom to make a harsh, rigorous contract to make a generous contract. And they made a very, very pro-lessor kind of contract. And it was very specific on this. We talk about Section 10 of the lease agreement. It talks about you need the prior written approval for an assignment, which approval shall not be unreasonably withheld. Now, if you stop there, you think, oh my God, they unreasonably withheld this, but it goes on. Which approval shall not be unreasonably withheld, delayed, or conditional, provided, however, and there's the kicker, provided, however, that in the event lessee shall be in default of this lease, lessor may elect not to approve any proposed assignment based upon the default. And you think to yourself, well, default, that's got to be something huge. Nope. Section 11.1 says a default is defined as a failure by the lessee to comply with or perform any of the promises, covenants, obligations, or agreements stated in this lease.
So, Mr. Evans?
That's it.
So I think...
I win, they lose.
I think that that's a good distillation of one's argument. But I think so. This is what you're saying. Check me on if this is wrong. So on August 6th, they say, we wish to have an assignment, and they say we're going to pay the $500. Let's say that at that moment there's a telephone conversation going on between the person submitting the email and the person receiving the email, and then your person could say, aha. You haven't submitted the $500. I see your email just came in 2 minutes ago. And then 3 minutes later, High Desert sends in the $500. So under your position, they would have had this default 5 minutes ago, and they would forevermore be barred from electing to assign and submitting the $500 because under the language you just read, the way you're reading it, that default forevermore forecloses, and you're entitled to never let them assign, right?
Yes.
Okay.
I know that sounds a little weird, but it says together with. So here's my assignment. It's got right here, there's the money, there's the check. Or put it in the same envelope, however you do it, or maybe do an electronic transfer instantly at the same instant. But if you don't comply with the exact terms of the contract, you're in default. That's what this contract says. It is not a contract. If I were advising somebody, I would say, don't sign this thing. This is ridiculous. Look at this. How many pages this thing is? It's enormous, and you can't even read the print without a magnifying glass. Why in God's name would you sign something like this?
So does it apply to, you're saying it's any breach. It's not, it could be, 10 seconds even.
Yes.
Okay. All right. We'll take that. It doesn't even have to be material then.
No. Well, the materiality is...
Does the lease address material breach? And if not...
I don't think so.
Okay, then don't we look to case law?
No.
Why not?
Because this...
So they wrote a contract that said Arizona case law does not apply to this
I
contract.
don't think it says that. Then maybe it does. That Arizona law applies, but...
But even if they did, would that be enforceable on this court?
Yes.
How so?
You go with the plain terms of this contract, what it says, and it says, together with, right that instant, you provide the money right then and there. If you don't do it, you're out. As far as materiality, it doesn't talk about material, immaterial.
But
it just says...
The trial judge made a specific finding that this was not a material breach. Even the court said, look, I'm not even gonna mess around with this $500 payment issue or whether that was a breach. Assuming it was, it's not material. And the court made specific findings, and because your client hasn't challenged that on appeal,
Right. Well,
that's the law we're dealt with in front. That's what the law is in front of us. We have a binding order from the Superior Court that says it was not a material breach.
You have an order from the Superior Court. It's not binding on you. You can unbind anything you want. But it doesn't matter. I mean, the Superior Court thought this was inconsequential, immaterial, didn't matter, wasn't important. But the contract is very specific. Any breach, boom. Then you go, at that point, once there's a breach, the lessee may terminate the lease. The lessor may elect not to approve any proposed assignment if there is a breach.
But their actions,
a default.
Landlord's actions here they completely contradict its position. I mean, they did the due diligence. They waited a month and a half and did the due diligence and said, oh, by the way, yeah, no, we're done. We're not going to accept this, your assignment, we reject it. And by the way, we're not going to mention anything about this $500 argument that we're going to hold in our pocket, perhaps for litigation purposes. I mean, they don't even mention it. When they do the rejection letter, the $500 fee is not even mentioned.
And in fact, they proceeded with due diligence and operated as though it wasn't a breach.
It doesn't matter. At that point, when they did not provide the $500 along with a written request, that's it. At that point, the lessor can act not to approve any proposed lease, and it says in that same clause, without the necessity of any notice or cure period. You don't have to tell them. You don't have to give any notice. You don't have to have any cure period. You're out. Once you're in default, you're out. That's why I say this is a very rigorous contract. Nobody in their right mind is going to sign this thing. Well, I can't say that. These people were in their right minds. They're not incompetent. But a commercially cautious person would be disinclined to sign this. If you're a lessee, you would not want to sign this. You want to give yourself all the escape hatches in the world, and they didn't.
So
somebody came up with just this monster of a lease.
So, counsel, I'd like to return to Judge Payton's question that we started with, which I really like as a question. And, if you do appeals in Colorado, they require you to break out as a subpoint in your Roman numeral where in the record you preserved the argument. So I'd like to say very specifically where in this case was the, quote, attempt at an assignment, unquote, argument that you make in your appellate brief preserved in the court below. Where did that happen concretely?
I already gave up on that one, didn't I? I'm pretty sure I did.
Well, you said the court implicitly accepted it was at issue.
Yes.
I'm just trying to see if there's a place in the trial you contend that happened. I'm just seeing if there's some there.
And I've been scratching my head over this for a couple of days. I think that when you go to somebody and say, I want to have a written, here's my writing, I'm going to do this assignment thing, I want your approval of it. That is an initial step of an attempt to have an assignment. So if you look at it that way, it's right in front of us. If you look at it, well, you've got to have some sort of extra thing going on that's not in front of us. If you follow my reasoning there?
I'm asking where the litigation position attempted an assignment the way you construe it in the Court of Appeals was preserved in the trial, but your initial answer, which I'm happy to take, is that you said you gave up on it. I mean, if there's a specific place that happened, I'd be curious to know.
In the formal sense, sure, but logically speaking, and I say it's like you're on the railroad track and you're looking the wrong way and the train's right behind you. If you turn around, the train that's right behind you they are attempting the assignment by sending the letter saying we want to have the assignment. That is an attempt at the assignment. In that sense, I don't know if that satisfies the contract, but I don't have to satisfy that part of the lease in order to prevail here. I simply have to convince you that together with means at the same time. And logically, I mean, how can I, for once in my life, how can I lose on that point at the Court of Appeals? I mean, together with, here's my written request for an assignment, and together with it, I'm giving you the money. That's just logic, and that's just common usage of the English language. I don't know how further to batten down that point.
Counsel, you quoted us part of the lease that talked about that the parties aren't required to give a cure period. Can you give me the citation for where in the lease that is? Mm-hmm.
Oh, it's in the, it's APP 124, which is part of the big answering brief, APP 124. It's section 10, about 2/3 of the way down.
Okay, thank you.
Okay. All right. So I've got lots of time and no questions, so I'll sit down and save my time.
Okay.
All right, thank you.
Good morning, Your Honors. May it please the Court, my name is Eric Frazier on behalf of the plaintiff, High Desert Healing. I'll start with this attempt at an assignment argument. It seems like we have a pretty clear admission that this was not in fact raised below, and we also don't have the transcripts, which frankly is my favorite issue in this case, because if you're appealing from a trial you need to provide the transcripts. Otherwise, this court can assume that all of the evidence, all of the arguments supported the Superior Court's finding below. We don't know, for example, whether there was any discussion about this contract. Presumably there was. Presumably the attorneys below made characterizations of the contract. We don't have those because we don't have the transcript. Now, in the reply brief, CEC said that the transcripts would be coming. They're not here. It's frankly too late now. Once the answering brief was filed, it's too late to add any more transcripts. That's obviously the simplest way to resolve this case. On the material breach issue, CEC has pointed to this language that any breach counts in this lease. That was true with the contract in Lomans. In Lomans, where the Arizona Supreme Court adopted the immaterial breach doctrine, the contract there said any breach would allow I think there was also a landlord, allow the landlord to terminate. But the Supreme Court and many other courts and the restatement and practically any source you look at says we don't allow landlords to terminate a lease for a trivial or immaterial breach. And this is the classic trivial or immaterial breach. It's $500.
Was Lomans the lockout case? Did they lock out the?
I think they threatened to. I think they threatened to. I don't think they actually did, but I may have been maybe misremembering that.
Do you recall what the breach was there?
The breach was about payment of common element fees. There was a dispute about how much fees were owed under the lease for the common elements, and the landlord sent, I think I'm getting this case right, the landlord sent a letter to the tenant forwarded to like corporate headquarters, and that took a few days, and then took a few more days and went to the wrong person and so on, and eventually the money was paid late.
Eventually, it was overall was a sort of a trivial amount.
It was a trivial amount, and it was a trivial, essentially a trivial amount of time too. And that's what we have here. This is a $500 fee in a multi-million-dollar lease. And this fee was paid. There's no question this fee was paid. It was paid with the next month's rent, which is when we said we would pay it. We gave the example in our brief of if you have an ongoing, recurring relationship with a vendor of some sort, and there's a trivial fee that's due, it makes complete sense to add that to your next month's. I think the example we gave in our brief is you have a lawn service and they say, I fixed your sprinkler, it's $5, you add it to the next month's payment. You don't mail a check for $5, and you don't have to. Here, together with means in addition to. And we don't just have the dictionaries, one of which is print, Garner's Dictionary of Legal Usage. It's a legal usage dictionary, not just a word dictionary. We also have the other uses of the term together with in this contract. The contract uses the term together with multiple times, and every single time it uses it merely as a conjunction to combine two things, meaning in addition to. So here, what it's doing is it says to get an assignment, to get our consent to an assignment, you have to do two things. You have to submit a written request in addition to paying $500. We did both of those things, so the landlord processed the request, denied the request on the merits, not for failure to pay the $500, or excuse me, not for the delay in paying the $500, but because of other reasons that the Superior Court found were pretextual in an effort to extract higher rent. I don't think those findings are challenged on appeal, so I won't dwell on those. But really, there are three ways you can affirm this judgment, plus a bonus way. First, as you know, the Superior Court found that the refusal to grant consent to the assignment was unreasonable and pretextual. That alone allows you to affirm the case. Second, the Superior Court held that High Desert did not breach the lease. That also allows you to affirm the judgment. And third, the court found that if there was a breach, it was immaterial. That is a third reason why you can affirm the judgment. Any one of those is sufficient to affirm. And the bonus way, again, my favorite way, is there are no transcripts here, so we don't even know what happened below. So we have to assume that everything the Superior Court said was supported.
Well, I mean, if I understand Mr. Abney's argument correctly this morning, based on Judge Jacobs' hypothetical, like, unless the payment was made I mean, that would be a legal, he's making a legal argument that if the payment was paid 10 seconds late, it's a breach. And there was no cure period, end of story, game over. What's your response to that?
So I have a few different responses. The first response is he never made that argument below. We don't know where he made that argument below because there are no transcripts. We don't know what the parties said, what the witnesses said, what the attorneys said, what anyone said about the contract below because there are no transcripts. Second response is that's not what together with means. Together with means in addition to, not simultaneously with. I mean, one thing is in writing, one thing is a payment. We know how commercial leases work. You know, it's not going to be, it's impossible to make a payment within a nanosecond of supporting or of making the written request. So I think his position that a 10-second delay would be a breach of the lease is absurd and is not an appropriate reading of the contract. And even if that was correct, we still go back to the immaterial breach doctrine, that no matter, even if a lease says that any breach allows the landlord to terminate, as it did in Lomans and as it did here, that's not how the courts interpret that, because Arizona courts do not allow a landlord to terminate a lease for a trivial or a technical breach. So even if a 10-second delay in making the $500 payment in a multi-million-dollar lease is a technical breach, even if that's true, it's an immaterial breach.
One might say the law abhors forfeitures.
What's that?
I said one might say the law abhors forfeitures.
We do say that. Yeah, I think Lomans said that. That's right.
Yeah, I didn't coin that phrase.
I don't think I have anything else, but I would be happy to answer any questions the court has.
Further questions? Okay, thank you, counsel.
Thank you.
Mr. Abney?
I also abhor a forfeiture. But this isn't a forfeiture. This is, you comply with the contract or you don't comply with the contract.
Mm-hmm.
And when you talk, I keep hearing breach, 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 breach. Okay, that's great. But what the contract actually says, lessor may elect not to approve any proposed assignment based upon the default. Default is a term of art in this particular contract, defined as a failure by the lessee to comply with or perform any of the promises, covenants, obligation, or agreements. That's what we're talking about. We're talking about default. We're not talking about a breach. It's miles apart.
But again, you don't know what default meant at the trial because you've essentially waived reference to the competing testimonies that could have been advanced. Is your position that default could never possibly be construed to exclude minor or trivial defaults?
As a matter of law, I mean, the trial judge found that on a certain day, when was it? Just a second. The request for written approval of the assignment of lease was on August 6, 2021. The $500 was not tendered until September 1, 2021. Those are facts established in the under advisement ruling. That's what we've got. Let's say, is that together with? Is it simultaneously? No, not at all. And we do have some extra guidance on what together with would mean in the it's APP 124 again. It's section 10.1 E. Each assignment request shall be in writing, accompanied by information relevant to lessor's determination as to the financial and operational responsibility and appropriateness of the proposed assignee, including but not limited to the proposed assignment terms, together with a fee of $500 as consideration for lessors considering and processing said request. So you've got in writing, accompanied with, together with. It's all one thing. It's all at one time. You provide your written request for an assignment with the information that's in a particular form together with the money. And if you don't do it all at one time, you're in default. And if you're in default, then you go back up to the top. Approval shall not be unreasonably withheld, delayed, or conditioned, provided, however, that in the event lessee shall be in default of this lease, lessor may elect not to approve any proposed assignment based upon the default. Boom, we're done. We win. It's the contract. It's right here.
If it was material, wouldn't your client have asked for the $500 when it got the email?
Pardon me, Your Honor?
If the $500 was material to the performance of, services relating to the lease, wouldn't your client have asked for the $500 then to be forwarded rather than wait 25 days?
They can wait all they want under this contract. They can. It's their right under the contract and neither a delay in approval or disapproval, nor acceptance of rent or performance shall constitute a waiver or estoppel of lessor's right to exercise its remedies. Once again, we win under the contract on the basis of the default. And you can't get away from the contract. I mean, if you start doing that, contracts don't matter.
What about Lomans? Are you saying that recent Supreme Court case law overruled Lomans?
Yes, to the extent that Loman says that you can be shilly-shally and be loosey-goosey about contracts. You can't do that anymore.
Plus, they certainly didn't explicitly overrule it.
No. But if they're going that strongly with freedom of contract, which makes sense, then you're stuck with that. And there's a wealth of case law, and I put it in my opening brief especially, that says you're supposed to honor contracts and not rewrite them to make them better for one side or the other. And that's what this court would be doing, be rewriting the contract. You can't do that. And if you want to talk about philosophy and broad principles, when our nation was being founded, there was heavy reliance on philosopher John Locke, who listed the inalienable rights as life, liberty, and property. Contract, property. Now, Thomas Jefferson took a hold of that and twisted it a bit, became life, liberty, and the pursuit of happiness, whatever the heck that is. But at the time the Constitution was enacted, the important thing was property rights. In fact, you can even go to Jane Austen. All of her novels, everybody is so concerned about property, rights of contract, and all that other stuff. Dickens is the same way. It's in the fabric of our political structure and our legal structure that we honor contracts and we enforce them. There are fringe cases, as I mentioned at the beginning, where there's unconscionability as possible. But this is a sophisticated contract entered into between sophisticated parties, and at the very just before they signed it, if they acknowledge they carefully read it and reviewed it. They're stuck with it. Its terms, they carefully read them. They carefully reviewed them. And they agreed they were commercially reasonable. So if they're agreeing that this is commercially reasonable, they are stuck with that commercial reasonableness. And the trial judge doesn't get to come along later and say, well, it's immaterial to me, and it's inconsequential to me. No, you can't do that. You have to enforce the contract as written, unless there is something really bizarre going on here. And there isn't. It's just a typical contract. The only thing about it that's atypical is it's so damn detailed and so long and so anti-lessee that, as I said before, I would never advise a lessee to sign the darn thing. I appreciate your attention. I know it's a tough argument, but if you think about it, you'll agree with me, I hope. Thank you very much.
Okay. Counsel, thank you both for your arguments. The court will take this matter under advisement and issue a decision in due course. The court is now adjourned.